Hey everyone, welcome back to Objection Psychology, the podcast where we put the human mind on trial and explore the psychology meets the law. I'm your host Lazaro, and today we're going to be on episode 2, Insanity, or is it just an excuse? Now before we get into it, I just want to give a quick shout out to everybody who tuned in for episode 1 and reached out and, left reviews, listened to the podcast, added it to the list, as it's very much appreciated for somebody who's starting up so new. So you guys are amazing. As promised in episode 1, we're going to be diving deep into the intricacies of one of the most controversial, misunderstood topics in the criminal justice system, which is going to be an insanity defense. Now, insanity defense raises a huge questions about morality, mental illness, and personal responsibility. Whenever we're talking about insanity defense, we're sort of evaluating, is someone truly not guilty if they were legally insane at the same time of the crime, or is the insanity plea just a legal loophole used by criminals and attorneys in order to get out of a court case? So let's break it down. So first, you might not even know what insanity defense actually is. So first, what do we say, or what do we mean whenever we say insanity defense? Contrary to what a lot of people may believe, popular belief, and definition that people have of insanity defense is that this isn't just someone that's claiming, hey, I'm crazy, I didn't really know what I was doing, and I just did it. It wasn't me, it was like an alternate person doing it. And this is a legal standard. It's not necessarily a psychological one. In most jurisdictions, the test is whether the person could understand the nature of their act or know it was wrong at the time of the offense. The most famous version is something that we briefly touched on last episode, which is the M. Naughton rule. And it comes, I know I didn't really dive into too much deep in what it was, but it comes from an 1843 British case, which involves Daniel M. Naughton, who shot the British Prime Minister's secretary, thinking he was being persecuted by the government. The court ruled in this case that M. Naughton was suffering from delusions and couldn't really distinguish the right from the wrong. And this rule that was established, back in 1843, which is now the M. Naughton rule, still forms the basis for a lot of the insanity laws today. And now there are also other standards. There is the irresistible impulse test, the model penal code substantial capacity test, but they all essentially revolve around the same idea. And that's the one that poses a question: was the defendant so mentally ill that he or she lacked culpability? Having said that, this is where now the psychology part of things will meet the law. And here's where things really get tricky. So psychologists and psychiatrists don't necessarily diagnose people as legally insane. They instead use clinical criteria, conducting, clinical assessments and researching up on their DSM-5, looking at all of the conditions and stuff. And they sort of use this clinical criteria, which are things such as schizophrenia, bipolar disorder, dissociative states, and then assess how these disorders may have impaired the person's mental state at the time that they committed the offense. One important distinction here, however, is that just because someone has a mental illness doesn't necessarily mean they qualify for an insanity defense case. Most people with mental disorders aren't necessarily insane, whenever you speaking in quotes, to a court and to a judge. As most people with mental disorders usually know right from wrong. So the legal threshold for this is very, very high. And then in case you're wondering, insanity defense isn't necessarily used all the time. I know that it's something that, courts talk about, and you see in a lot of YouTube videos, and you see a lot on the internet, how these criminals get out because they ruled insanity defense on them. And I mean, it's actually quite rare. So studies, I kind of did a little bit research on my own. I just found that studies, it sort of ranges around that 1% margin on how 1% of, or even less. I found, statistics that reported less, but 1% of felony cases are reported insanity defense. And of those court cases that make insanity defense cases, only about a quarter of them are successful. So, to the common misconception, insanity defense isn't necessarily a get out of free jail card. In fact, many who are found not guilty by reason of insanity end up usually institutionalized in a psych ward, which, you can make a case for whether it'd be better or worse conditions, but it's usually longer than they would just have ended up serving in prison. Now let's dive into, some high profile cases, which takes us to about our third segment of this podcast. And there have been some high profile cases across history. We're going to be talking about some really important ones that really marked the history and set a precedent for the courts when talking about insanity defense. So the first case that we're going to talk about is that you probably, or you should know, our President Ronald Reagan. I have no clue which president he is of the United States. I just know that he was a president. But you might or might not have heard of the person who shot him, who is John Hinckley Jr. And John Hinckley Jr. shot President Reagan in 1981, and it turned out to be a very controversial court case. Hinckley was found not guilty by reason of insanity, which immediately sparked national outrage and led to a lot of reforms tightening the standard for insanity pleas and insanity cases in general. This was just the beginning of what the insanity cases would actually be. Imagine that somebody who, let's just put in today's case, shoots President Trump, and they are deemed insane, and they don't end up going to prison. Instead, they're just institutionalized in a psych ward, which may or may not be better living conditions, but at the end of the day, to society's eyes, they're not really serving their sentence, and they're not necessarily getting their deserved punishment. More recently, you might have heard of the case of Andrea Yates, who drowned her 5 children in a bathtub. Andrea, who was initially convicted of murder, her conviction was overturned on appeal, and she was later found not guilty by reason of insanity, as she said, and as she was diagnosed, that she was suffering from severe postpartum psychosis. For those who may not know what postpartum psychosis is, it's considered a severe mental illness that can occur after childbirth, which is characterized by rapid onset of psychotic symptoms like hallucinations, illusions, and disorganized behavior. This, by the way, is directly quoted from the Cleveland Clinic, and it was accessed in the year of 2025. So, cases like these really reveal how uncomfortable society is with the idea that somebody can commit a violent act and not be held criminally responsible. And then it feeds into the myth that insanity defense is just a trick, something that, lawyers or attorneys usually use in their cases to argue a case for their clients in front of a judge and use it to let these dangerous people off the hook. But then here's the reality about that. It's really incredibly hard to fake insanity, especially under the forensic evaluations and psychological assessments that these people are faced under. Psychologists look for consistency, past psychiatric history, and conduct thorough assessments to, really get the truth out of these criminals. Malingering, which is faking a mental illness, is actually very, very, very rare and is usually often detectable. I read a couple of months back how, reading up on insanity defense, coincidentally, that 1 in 1,000,000 people can actually endure the process of malingering and fake a mental illness. Taking us to segment 4, let's pause and ask the big questions. If somebody commits a horrific crime but was truly psychotic at the same time, should they be punished the same way as someone who planned it with full awareness? What if the person became mentally well years later? Should they be then released from the psych ward or their institution? Or how about this? What if someone with a known psychiatric disorder refuses to take medication and then later goes on and commits a violent act? Are they still not responsible for this violent act? And these aren't just legal puzzles, they're moral ones. The insanity defense sits at the crossroad of justice, compassion, and public safety. And while it's far from perfect, it reflects a powerful principle. We really can't, and we shouldn't punish people who can't understand what they're doing. But now I want to spark some curiosity from the audience. So, let's say that you have a friend, right? Let's say that you have a friend, in the most hypothetical example, so this isn't necessarily a real situation, but in the most hypothetical example, your friend goes on and commits murder. Let's say that you then choose to represent this friend in a court case, and you go through all the paperwork, go through all the processing, and you finally reach the end to where you'll be talking to a judge. Let's say that, the judge gives you, let's say, a couple hours to plan your defense. Obviously, this isn't real in real court cases, as these often take years, months, whatever it may take, not just mere hours. But let's say that you're given a couple of hours to really prepare your defense and, help prepare the best case to get the least amount of sentencing for your friend. Let's say that he's trialed for first-degree murder. And let's then say that he is faced with, let's just say, schizophrenia or amnesia or dementia even. I've seen dementia being used in these cases. So if he's faced with dementia, should he then be allowed to be able to use dementia as a way to get out of the court case? That question, I'm sure, will spark a lot of curiosity from you guys, the listeners. And it surely did for me. Obviously, this isn't a show where I really dive or really want to share my personal opinions, but realistically, it's not wrong to admit and assume that insanity defense is a big part of today's legal court system, and how it's constantly being used now more than ever as mental health continues to be a topic of discussion. If you really think about it, as I was saying in our previous episode, it's really incredible how mental health and societies for mental health and depression, and how even psychiatrists have been more in demand and psychologists have started to become more in demand, as mental health continues to be a topic that is often discussed and is constantly in need of demand as the newer generations just continue to keep on sparking it. At the end of the day, heading into our last final segment here, at the end of the day, insanity defense forces us to confront what we mean by responsibility and what it truly means to be human, as it really makes that distinction from being human and being humanly insane. It's easy to judge from the outside, especially when emotions run high, but we have to unfortunately accept that mental illness is real, and that mental health is starting to again become a topic that is continually talked upon. And the law about it, while imperfect, tries to make room for this brain and human complexity. So here's another thought to leave you with. Can a just society make room for compassion, even when the outcome is deemed uncomfortable? Let me know what you think. I love to hear anybody's opinions, and I know that whoever's listening to this podcast is in their own pursuit of knowledge, and I'd love to see what you think and give me your thoughts on insanity defense as a whole, and let's just spark a conversation. Like I said, the best way to spread and to learn knowledge is to discuss about it. And that's it, everybody. That's it for episode 2 of Objection Psychology. I appreciate all of you guys hanging out with me today. I know today was a short episode. Last episode 1, was really just a test run. And I felt like I was speaking a lot slower in that episode than this one. I figured you get more and more confidence as the time goes by and as you make more episodes. So I appreciate everybody for going on this learning curve with me and being able to, like the podcast, rate it, follow, download it. All of those really help a lot. And like I said, if you're feeling extra generous and extra, you want to give a little discussion, I leave my email at the bottom. I have 2 emails. I'm sure you can find one in the bio, and then I leave one at the end of episode descriptions. So it really helps me grow, and it really helps the show grow, as, like I've said, we both embark on our pursuit of knowledge. Next time on Objection Psychology, we're going to be talking about false confessions. So people who confess to a crime they didn't commit. That episode's going to be really interesting. We're going to be talking about why does it happen, and how do psychologists help spot the signs that somebody is confessing to a crime that they didn't commit. So we're going to try something different. We're going to try something new. It's going to be a little bit different of an outro. You guys let me know if you like it. Stay curious, stay critical, and as always, objection sustained.